Good afternoon, everybody, or good morning for the ones which are in the US at the moment. We are really pleased for Juris Diversitas board to welcome you on this session. We will be discussing very interesting topics, and we will travel around because we will be in the US, but as well in the Philippines with Professor Becker. So I will introduce those three speakers of this afternoon session. We will have, so ladies first, even if Professor Demletner will be the last one to speak. I am presenting you because you are a professor at Washington and Lee University. You are highly specialized in criminal law, and you will be talking today about the US criminal justice system seen through the lens of law and order with a TV show, SVU. So it's a very original presentation that we will have to finish this session. Before we will hear Professor Biagio Ando, who is kind enough for welcoming us virtually because you were in charge of organizing the Juris Diversitas Congress in Catania. And I still remember your faculty of law because in Catania, the faculty of law is in a magnificent building which is surrounded by lava from the volcano, from the Etna. And I still remember my stay in Catania. And so I'm really sorry that you made so many efforts and at the end we couldn't be all together. So thank you for your efforts and for speaking today about charting the frontiers of corporate rights in the US legal system towards a full-fledged personhood statute paradigm. So it will be a journey this time in the US Supreme Court case law, and that will be very interesting. And after, we will have Professor Becker. Professor Becker is teaching at Louisiana State University, so he's a colleague and working next door to Olivier Moreto, the president of Juris Diversitas. And we are very pleased because Professor Becker is a highly specialized professor, and he will be talking about maximizing the US Constitution, the common law and private law system, Louisiana, Puerto Rico, and the Philippines. So it will be a journey, and we will have a lot to share, and I can see how many discussions you should have with Olivier Moreto, because you're sharing a lot in comparative law. And so I leave you the floor now, Professor Biagio Ando, to start your presentation.
Thank you, Anne. Thank you, Olivier. And it was a pity not to be all together in Catania, but we'll have another occasion to meet. I will deal in these 20 minutes of my presentation with two pillars. On the one hand, constitutional freedoms, some constitutional freedoms. On the other, corporation. There are some reasons underlying my choice why a non-US lawyer chose this topic. There are some reasons which are related to my background, and namely the fact that recently a judicial trend acknowledged the possibility in some cases of recoverability of non-pecuniary losses to corporation. And this is, I would dub it as an internal factor. There are other factors which steered my attention and make me focus on this topic, more or less direct. The one less direct was that I was carrying on a research on privacy in the US legal system, and I was trying to understand why still at present, there are some, I would define them bottlenecks, hindering a full-fledged protection of privacy in the tort law realm. And my attention was driven by the fact that probably a concurring factor is the lack of a corresponding taxonomy familiar to the European legal thought of right of personality. So my attention to corporate personhood was an attempt to see some issues concerning personhood from a different angle, from a different viewpoint. And third, the fact that at first sight, I was impressed by the fact that this discourse on rights, on corporate rights, was separated to a certain extent from the ground which may seem natural when the discourse on rights is at stake, namely the liability. So what I realized is that the current discourse on corporate rights is partially separated from issues related to corporate liability, especially when international law duties or obligation are at stake. So this is the situation, the set of issues which are the framework of corporate rights is quite complex, is a composite puzzle. I'll try to single out a short tile, and probably I will provide you with more questions than answer. The two major questions I try to frame are, is the core of fundamental rights involved in corporation cases identifiable in the same way for natural and legal person? And how does, as to corporate right, the economic aspect related to the enjoyment of rights come at stake? Second question, which are the scope and the rationale of, I would say, legal subjectivity when referred or bestowed on legal person? These two scope and rationale are always the same throughout time, or they undergo a substantial change? I focus on two major judgments issued by the Supreme Court, which, notwithstanding the fact, despite the fact that they cannot be considered recent or very recent, they highlight a trend which is still ongoing and which leaves the floor open to solution and to further problems, namely the Citizen United versus Federal Electoral Commission, issued in 2010, and the Bauer versus Hobby Lobby Stores, 2014. The first case arises from or as to the federal law prohibition issued to address to corporations and union to use their funds to make expenditures for speech amounting to electioneering communication. That is, communication having for object a clearly identified candidate for federal office made a short lapse of time before a primary election and publicly distributed. In this case, a corporation wants to distribute a movie about a candidate for the election among the candidates for the Democratic Party, highlighting, let's say, some, I would not say good qualities, but defects or flaws about her personality. And in this case, the court, returning a important president, the Austrian president, understood the limitation on expenditures as limitation on the freedom of speech. What was at the core, what lies at the core of this judgment is the fact that freedom of speech has to be recognized, not caring to the identity, to the speaker's identity. Just a few passages to give you the flavor of this judgment. Speech is an essential mechanism of democracy, for it is the means to hold officials accountable to people. Premised on mistrust of governmental power, the First Amendment stands against attempts to disfavor certain subjects or viewpoints. The government may not by this means deprive the public of the right and privilege to determine for itself what speech and speakers are worthy of consideration. So the so-called marketplace of ideas is at the center, and the main need, the main issue is that of ensuring the enjoyment of this freedom, not despite the corporate identity of the speaker. And the argument which may be found against this restriction are dismissed by the court, such as the anti-distortion argument, the fact that the immense wealth kept by large corporations may enhance their views and their aims at the expense of other less affluent, less powerful speakers. The so-called, I define it in this way, the argument against possible corruptive or corrupting effects linked to the enjoyment of the freedom of speech, and not even the argument related to the protection of shareholder as being taken in account. So freedom of speech must be ensured to corporation and to natural person. And what is interesting, I say it looking at distance to this judgment, is that money spending is seen as an important vehicle for the enjoyment and use of the freedom of expression. And well, this passage of the reasoning of court may be probably criticized because, when a rights is linked to spending, depends on the ways in which this right is ruled by the political decision maker. It may be that a right is left out of the market, or partially out of the market. But this is my view, of course. This belongs to the distributed mechanism of goods linked to rights decided for by the political power. The second judgment I took in consideration is the Bauer versus Hobby Lobby in 2014. In this case, some regulation issued by the Health and Human Services under the Patient Protection and Affordable Care Act of 2010 requires a specific employer's group health plan to furnish preventive care and screenings, so impose the coverage of some medical treatment to the employer's health plans. In this case, what was at stake was the coverage of the cost of some contraceptives. The fact is that this judgment is rendered, I mentioned Hobby Lobby, but there are several judgments which have been considered by the court in this case, and in all these cases, corporation, closely held corporation are at stake. That is, big companies, but whose shares are not widespread, are in the hands of few shareholders. And these shareholders hold very strong religious belief. In this case, HHS and the other federal agencies are sued by the owners and not the companies. But these regulations address themselves to company. So they place a financial burden on employers, on companies, and not on religions, and not on physical person. There are some subjects which are exempted from this burden, such as churches, such as religious non-profit corporation, but in this case we are addressing claims issued by for-profit corporation. Differently for the former judgment, the issue is not that of constitutional adjudication, but rather of statutory. The judgment is based on a statutory grounding, and at stake is the possibility of read coherently this regulation under the Patient Protection and Affordable Cares Act cloak vis-a-vis the RFRA, that is the Religious Freedom Restoration Act, issued in 1993, which was issued in order to protect the aim or the interest of the free exercise of religion by persons. The problem, legally speaking, is this one. What is person? This act, RFRA, does not expressly provide for a definition. This definition is given indirectly by the Dictionary Act, which, concerning federal regulation, understand person as a term either referred to physical person or to legal ones. So in this case, this exercise of religion in the court's majority opinion has to be understood and protected in an effective way. Otherwise, these religious owners, this physical person holding very strong belief, would be placed before a very difficult choice: or giving up the right to seek judicial protection for their religious liberty, or forego the benefits which are linked to the form of to their operating as corporation. It could be said in passing, and it was really to be true stated by the dissenting opinion, that there is not such a dramatic choice, because of course the coverage acts when a woman, a specific woman, decide to avail herself of this treatment. But this was the choice made by the court. So even if the basis of the suit is different, the bulk, the core issues of these two judgments are the same: exercise of freedoms by corporation. I think that the conceptual framework which is underlying these two judgments is two-layered. On the one hand, there is a layer concerning cooperation. 5 minutes, oh, time runs fast, alas. On the other, the fact that there is an attitude which it was really patent, I would say obvious, at the beginning of the 20th century and triggered, for example, the seminal Lochner's decision. That is the fact that what has to be ensured is that the individuals have to be kept far from possible judicial intervention or political lawmaker intervention, which may be justified in the light of aims such as to give a remedy for social inequalities, so redistributing wealth, which is distributed naturally within the society. This is seen as an evil by certain layers, judicial layers. And this, in Lochner case, freedom of contract was at stake. And the fact that state law placed a cap to the weekly hours worked by bakers. But this freedom of contract has to benefit from a strong protection afforded respectively by the 5th and the 14th Amendment vis-à-vis the government and state. And this is one layer. The second powerful layer is the theory of cooperation, which worked throughout time from 19th century onwards, namely the so-called artificial entity theory. So what we see at work is apparently, at least seemingly at least, is an evolution, a development in at the corporate personal level. So at the beginning of 19th century, there was the view of corporations such as artificial entities. Corporations were not still conceived of as a part of a natural part, a familiar part of the economic and legal landscape. So they were seen as artificial being, invisible, intangible, existing only in the contemplation of law. So something which has to be, in order to exist, has to be acknowledged or recognized by the state, and having right only to tangible interests and not to intangible ones, such as free speech, privacy, and so on. Afterwards, there was a trend acknowledging a higher degree of autonomy to corporation. The theory, for example, the aggregation theory, the fact that the corporate rights are grounded on the physical person rights, and so 2 minutes. Okay, thank you. And so they enjoy. They have to. Their existence is grounded on the existence of physical persons' right. It's to a certain extent a way of keeping corporation far from state intervention. And the last step, in an oversimplistic fashion, of course, is that of corporation as real entities. So they are real entity. They are person according to the Jewish conception, but I leave it aside. Corporation as real entities represent the highest degree to a certain extent. But in this judgment, probably in Hobby Lobby more than the other, what is at stake is probably the coming back of an aggregation theory. Because what is put at stake on the fourth stage is the fact that owners, physical persons, need an effective protection in order to carry on their freedom of religion. And what happened is that throughout this complex evolution, the Bill of Rights, quoting from Karl Mayer, was transformed from the most cherished palladium of personal liberties to one of organizational prerogative. And the 1 minute left for the conclusion. And probably the reasoning is as a circular form, because we come back to the point of departure. The fact is that this flow of cases, this flow of judgment are two layers, rest on two pillars. And the paradigm of neutrality, non-interventionist attitude, simple inaction is better than proactive action, is one of the pillars. The other is the larger and larger acknowledgement of cooperation as real entities, quite often, so leading to the expansion of their sphere of freedom and rights. This expansion does not go hand in hand with their liability. Conceiving of corporation as person is not bad per se. Well, it would be better if corporation were required at the same time to act as good citizens. But this achievement has not even been made. Whether this state of thing is a good thing or displays a law's dark side, well, I leave this prudent evaluation to my audience. Thank you for the attention.
Thank you so much for keeping the time, because I'm really sorry for this session, because we've got the general meeting, the plenary session just after, so we are short in time. So thank you very much, and it was really enlightening. So thanks a lot. John Becker, the floor is yours. Can you activate your microphone? And even if we cannot see you, we can hear you. So that will be perfectly fine.
Well, it's a challenge, therefore, to play with my voice in order to make it more interesting in some way. You know, there's a saying regarding television and radio in this country. They say that people may have a perfect face for radio. So I will, in that context, I will do my best to sound more like a radio announcer. First of all, I'd like to thank you, of course, for being the moderator of this session. And I can't say enough about my colleague, Olivier. And as we were having technical difficulties at the outset, I thought there's nobody better to preside over this, because Olivier never gets flustered or excited about anything that's a problem. He just kind of flows right through it, and it all seems to work out well. So
if you've got, sorry, John Becker, if you've got PowerPoint, you can now share
I don't,
the PowerPoint.
I don't use PowerPoint.
I activated it. I managed.
Thank you. So when I came to Louisiana, I had no idea about this strange state that had two different legal systems. And, you know, what is this? And I got into the faculty and I found, well, we have a lot of people from other countries here. Why? Because Americans don't know much about civil law. And then later, when we had Americans who were teaching civil law, you could see a clear divide between the true civilians and the American civilians, except for one, a now deceased famous professor at LSU anyway, who understood both systems clearly. Anyway, what I later learned was the Roman law background to the US Constitution. And so with that and a minimal understanding of civil law from a procedural point of view, because Louisiana was the first state in the Union to get rid of the common law as a substantive body and created the first criminal code. And the code, before the district attorneys in the state got to it and botched it all up, it was a beautiful piece of work. I mean, everything fits so well, and it was also well attuned to the procedural requirements. Anyway, that's what started me on all of this. Now, my specific concern here today is about federal systems, because our federal system is really a pluralistic legal system. As I see mostly in looking at the website and information about Juris Diversitas, I see the word hybrid used. I don't so much see the word plural used. Now, some people use them interchangeably, but a federal system, whether it's a federal, state, or a confederal system, is a pluralistic legal system. And the great complexity, which our previous speaker was referring to, didn't even get into pluralism of the federalist kind. He was just dealing with federal law, statutory versus constitutional. And when you throw in the federal mix, it's even more complex than you could possibly imagine if you've not done a deep dive into it. So, what do I want to do in this session? I picked out these 3 different jurisdictions because, well, I refer to them as the 3 schizophrenic jurisdictions that I am familiar with. That is, I want to talk about what they have in common, what they don't have in common, and what insights this really gives us about federalism and statehood in the nation state sense. Because historically, of course, the French Civil Code was designed for a unitary state. And whenever I want to contrast the United States with someplace else, it's always France, because I enjoyed teaching there, thanks to Olivier, for 11 years. And it really is wonderfully different. And that kind of diversity, difference is not known to enough people in many countries. And it contributes so much. So every time I go abroad, and right now I'm teaching in China via Zoom, you get a totally different perspective, and it helps me understand much better our own Constitution. So what do these 3 jurisdictions have in common? Well, all of them had a civil law system before the United States came in. Now, obviously, in Louisiana, and I'm not going to get into this debate, I leave that to Olivier, it was French-Spanish, depending on which law professor you talk to who teaches civil law, how much was in the balance there. But it's clear that in the Philippines and Puerto Rico, they had a Spanish civil law. Now, there's more complexity, and I'll get into that when I talk about the differences a little bit. But the other part, what happened when the US took over each of these places, the first by purchase in Louisiana and the other 2 by conquest, basically as a result of the Spanish-American War, and it was part of the settlement of that. The deal was made that, okay, you can keep your civil law. I mean, because one thing, we don't want a revolution there, okay? We're not going to upset your family life. We're not going to upset your property, but we insist that you adopt the common law for your public law, which as a practical matter meant mainly criminal law, and of course the Constitution. But initially, all of these places were territories, and Puerto Rico still is a territory. What that meant was effectively they were under the control of the US Congress and the executive branch. So there were certain constitutional rights applicable, but not the full scope of it at all. So that's the basic hybrid situation that occurred in all of these 3 jurisdictions, but they occurred at different times, obviously. The Louisiana Purchase back in 1803, and then the Spanish-American War much later. And of course, you have different political ideas driving the federal government at the time when they were dealing with each one of these situations. So, what's different about them? Well, in terms of, let's say, status, in Louisiana, it is a territory that's within the contiguous continental part of the United States, excluding Hawaii and Alaska. Now, that has made a big difference. Why? Because Americans flooded, especially New Orleans. And so if you go to New Orleans, the French Quarter was for the French. And then across Canal Street is the American Quarter. They didn't have much to do with each other. And they had different architecture and their buildings and everything else. But over time, the American influence became very strong. The French pushed back and preserved, thank God, the culture that goes with New Orleans. And what makes it interesting is not the American part, it is the French part. And I used to have a New Orleans center, international center that was funded by the State Department. And we had visitors from all over the world. And when the visitors from Latin America would come, especially if they came from, say, Nashville to New Orleans, they would just go, we're back home. They could feel the difference. And when I was working in Guatemala one time and we were meeting with somebody, the fellow said, businessman said to me, he says, "You really understand Guatemala and Central America?" I've only been there a few days. And I leaned to my colleague and I said, "It's no different from Louisiana. The only difference is we have a constitution that keeps us from going crazy like some of these other places." And I'm saying these things partly to be interesting, but partly to make a point. There is a connection in the whole structure of law, obviously, and that's something I don't need to press with any of you. So in the differences, when you go to Puerto Rico, there's not a clear message in Puerto Rico in the sense that the population is divided. Do we want to stay as we are in terms of the territorial status? Do we want to be a state, or do we want to be independent? That's an issue. And for me, I'm going to be doing a conference on federalism in the Caribbean. They had a short-lived federal arrangement some years ago, and there's still talk about federalism, but they could never be a federal state the way we are because they go back to the original Confederation idea of separate islands, but more about that later. So what else is different? Well, in the Philippines, they've got real problems. There are 7,000 islands there. And you would think it would be a confederation, but it's not. Well, the Philippines, unlike Puerto Rico, is much more complex. Besides the Spanish civil law and the Anglo-American law, there's Islamic law. And that's a big issue in the southern part of the Philippines. Moreover, there's indigenous law. So in the Philippines, you've got this split where when the Spaniards came in, they brought Christianity with them, and much of the country is Christian. But it's always been down the southern part in Mindanao and the other area close by, where you've had an Islamic presence that long predates the Spanish conquest. And it was a relatively peaceful at the time Muslim territory in which they were engaged primarily in commerce, and the integration down there came through intermarriage, etc. In the 20th century, there were periods of strong violence in some of these areas. But the real problem in the Philippines is they claim to be a unitary state. The problem is that the presidents really try to exercise control over something that with 7,000 islands, it's very difficult to do. And more recently in this Constitution of 1987, they give, in theory, autonomy, and largely, I guess, now in practice, to the Muslim areas in the South. So what can this tell us about anything other than the fact that these are interesting places to which to travel? But I remember, Olivier, when I went in to give a lecture at the University of the Philippines, they had this female professor that I called the female version of our departed colleague. You know who I'm talking about. But she was Ms. Civil Law. And the strong presence that she had and the influence of it there had the same kind of ring that every student who went to LSU Law School had from our dear departed colleague. And that made a strong impression that in order for the civil law in a hybrid jurisdiction to be significant, there has to be some kind of renaissance. And I don't know that there ever was really one in the Philippines, but you know, Olivier, that LSU under Dean Aber, there was a renaissance in civil law. And also in Puerto Rico in the 1960s through a Harvard-educated Supreme Court justice who also influenced education. So for the civil law in jurisdictions that are heavily overrun by common law Americans, the civilians have to be pretty forceful, not by force, but by force of argument. And there are many good arguments for the civil law. And I remember the chapter in Justice Scalia's first book, A Matter of Interpretation, it was that the US is becoming more and more like a civil law country. Well, in one sense it is, in the sense of statutes, but certainly those statutes don't have the coherence that a good civil code does. And that's one of the things that many common law lawyers who simply make the comparison based on statutes don't appreciate that a civil code properly drafted is intellectually coherent. That's not something that Ando, Professor Ando, in response to what you were saying, the reason you're having difficulty is you have a coherent approach to law. In the US, it's not a coherent approach to law. Once you understand that, the rest of it's relatively easy. So the fact is that how much time do I have left? How much time do I have? I can't hear you. Can you put your fingers
6
up?
minutes. 6
Okay.
minutes.
Okay, so I can go. I don't have to rush then. Louisiana, in conclusion, I want to draw, what do these comparisons and contrasts tell us, if anything? In a way, Louisiana is still an island, but it's less of an island than Puerto Rico, which is a real island. But there are different ways to be an island. And it is clear, for instance, on many grounds, that Hawaii is in a different world from the continental United States. And there's a strong secession movement in Hawaii. Very few Americans know this. I also consider Alaska an island because although it's not an island, it's basically not connected to the United States. And there was a weak secession movement up there. It's not in, it was over oil. They wanted to keep their oil and they didn't want to share it with the rest of us. But Louisiana is different still in many ways. Louisiana, thank God, has never been fully digested by the rest of the country. What do I mean by that? As not only I have noticed, but other constitutional lawyers have noticed that Louisiana is way overrepresented in US Supreme Court cases. And this is because there are often conflicts between the state's private law or public law and the US Constitution, more so than otherwise. So an LSU law trained lawyer is kind of a split personality. He or she may want to be more American, but the reality is they don't realize that they've actually been conditioned. So in the US Court of Appeals for the Fifth Circuit, which governs Louisiana, Texas, and Mississippi, the judges often would say, these Louisiana trained lawyers don't understand that unlike in state courts in Louisiana, where under the civil law, it's possible to raise issues of fact on appeal, you can't do that in a federal court. So there is this kind of dual mentality, and sometimes they don't understand, other than the fact that they think that way, they don't understand necessarily that it's a bilingual problem. We used to use the term bijural at LSU. In Puerto Rico, they're an island, which makes it difficult. They have a military importance to the United States, but frankly, not much commercial importance to the United States. The United States is more important to them, especially on tourism. And if Cuba comes back online, or when it does come back online, that's not good news for Puerto Rico. But in terms of integration, Spanish is the official language of the courts, whereas in the executive branch, the official languages are both English and Spanish. It seems to me that that makes it very difficult, where you've got Spanish language only in the territorial courts, and then you have in the U.S. federal courts, meaning the First Circuit, you have to have English. People down there speak English, of course, but it's a different mindset. In the Philippines, the problems are fundamentally different, in my view, and that is the fundamental problems of the Philippines are constitutional. Why? They don't have a good constitution. Okay, they just don't, and that's not unusual around the world, and it's not unusual within the United States. The constitutions of many states in our country are very, I would say, very defective, frankly. But in the Philippines, they're not under the U.S. Constitution. Louisiana is, Puerto Rico is. The Philippines was never intended, as far as I know, to be in the United States. It was, as I've read, from the beginning, the notion that it would become independent. In 1935, it became a Commonwealth, and then in 1946, 47, it gained its independence. The conflict in the Philippines from the outset was, what is the U.S. doing here, and what are they trying to do? And unlike the British, which didn't disturb legal relations in many of its colonies, those who were sent, at least initially, to the Philippines to govern it, their intention was to westernize them. And so Philippines has continued to be an important military base. There's actually a lot of integration of the Filipinos who come to the United States, but their real problem has been a system in which a president, often attempting to be very strong to the point of being dictatorial, is dealing with 7,000 islands and dealing with a totally different legal, cultural situation in the southern Philippines. There have been attempts, suggestions to turn it into a federal system. I would say it should be a confederal system. The Philippines really is not a credible unitary state. It needs some kind of federal system, but I don't know whether that's ever going to happen. But it seems to be moving slowly in that direction. I'm just about out of time, and I hope that even though you can't see me, I can see you, and it's been a pleasure to see all of you.
Thank you very much, Professor Becker. So now I will share my screen because I'm sorry.
Actually, I think we're fine, Anne. I think I figured out my technical problem, or maybe my teenager figured it out. So
it's what I said, but
Let me see whether I'm right about this. And can you see
Wonderful.
it? Okay,
Yeah,
that is
wonderful.
excellent. So I am switching our frame a little bit, and I am mindful of the fact that this is the almost end of the conference, and I'm the third speaker. So my focus is on the intersection of law, legal developments, perhaps legal change, and the representation in popular media, and in this particular case, a highly popular television show. I'm not arguing causality, but I am arguing that what we're seeing is kind of a mirroring of developments on different fronts. So the show I will tell you about today is called Law and Order. And it is actually part of a franchise that started in 1990 and has been going till now. And in fact, the original show has ended, but this one here, Law and Order SVU, that's how it's known, for Special Victims Unit, has been around since 1999, and it's now in its 22nd season, which actually makes it the most successful television show in the history of television. And it's already been renewed for 2 more seasons, which may give us a little bit of an insight of where US law enforcement and US criminal justice reform are headed. So let me just point out, I pulled the posters from the 2nd season, which is on top, and the current one, which is on the bottom. There are a couple of things that are obvious to everyone just looking at them. You know who the protagonist is in season 2. It's the gentleman who is the third from the left. He has, in the meantime, left the show. He was a quite abusive a cop, but he's now reappeared in a new franchise of Law and Order. The bottom tells you who the protagonist is now. Again, it's the third person from the left, but it's a woman. She's been with the show, and she's the only character that's been with the show from the start. You also notice that racial representation has changed to some extent. You now have 2 African Americans in the show. One's been in it now for probably 15 seasons, a very popular actor. The other one is relatively new. What you cannot see on the bottom, the current version now has a district attorney. It originally was just a police show. Now it has a heavy legal component. And you also have a now gay police officer who didn't exist in the original show. In the original show, everyone was cisgendered. So clearly some changes in the makeup of the show. But the original focus hasn't changed, and I'll try to kind of play you the introduction that's been the same since 1990. We'll see how good the quality of the sound is. You'll get the drift of what we're talking about here. The order is called, the show is called Special Victims Unit, but it's really a special unit for sex crimes. You will often hear them talk about how they are based on the Manhattan District Attorney's Office that deals with special victims. The Manhattan District Attorney's Office got a special victims unit in 2010. So obviously the show was not based on that. It is based on their sex crimes unit. And I'll give you a little bit of a sense of what they are talking about. Special expertise for sexual offenses, and in particular for working with survivors. You'll notice here the term survivor. I think every American, well, now our terminology has shifted from the victim of sex crime, the victim of crime, to the survivor of sex crime. So we have quite a kind of change in the terminology, which goes to the overall message of the show, and I think the overall message of the criminal justice system about empowering victims with respect to this crime. Now, in case you're wondering how one can fill 22 seasons with sex crimes, they are branching out from time to time. So this time they had a mental health breakdown, not sexually related at all, an assault, perhaps a homicide, suicide based on COVID. But we also had trafficking. We've had an anti-gay crime. We have had the psychopathic killer. So there's a lot of those, many of whom are recurrent. Now, you may be wondering, why am I picking, just hang on, why am I picking this show? Well, it's essentially become a cultural icon. The lead detective, the female, is called Olivia Benson. You notice Taylor Swift named her second cat after Olivia Benson. Just this May, a big story about the attempted abduction of a girl. And not only did she fight off the attempted attacker, she also said she put some sticky green slime or blue slime on him because she had learned that from Olivia Benson by binge watching Law and Order SVU. Now, mind you, she's 11 and she's been watching this on Hulu, where you can be seeing all these back shows. So this show is about more than just one of the many things that are up on television. It's often been credited with having brought a sea change to the perception of sex crime and to empowering victims. Now, this comes from an interview with Olivia Benson, aka Mariska Hargitay, and she talked about the show in terms of depicting empathy, compassion, and justice. And you have to see this in the framework of the victim. So it is empathy and compassion for the victim, and the goal of the show is to bring justice to the victim. Now, what does justice generally mean in this show is heavy punishment. Punishment essentially takes two forms for sex offenders in the show and largely in reality, at least for serious sex crimes. So we talk about the prison sentence, and then we talk about so-called collateral sanction, namely what happens after release from imprisonment, sex offender registry, and notification. So let me start with a prison sentence. The goal here, the goal in the show, and oftentimes you would think this is the goal when you listen to public discourse, is as long a prison sentence as possible. Ideally, no release. Now, in addition to that, it seems like prison alone is not enough. So you often have this evocation of prison rape. It comes up regularly as a threat that's being uttered by the district attorney, by the officers. You see Benson now, she says this in 2010. So this is not the beginning of the show. It has changed in the way it is being discussed. It is clearly now seen much more of a tragedy, but largely a tragedy for female offenders. So they had, for example, 2 episodes over the years where female offenders were raped by correctional guards. But male rape in prisons is still seen as something that just happens, and it's almost as if it were righteous that this happens in prison. The second punishment that the US Supreme Court had declared not to be punishment is the so-called sex offender registration and public notification. So this is a civil consequence that flows from a criminal conviction of a sex offender. Before 1994, different jurisdictions in the US had some registries, but they were not particularly important. Academics certainly didn't focus on them or ever write about them. In 1994, based on a vicious crime, the federal government passes a requirement that states need registries for convicted sex offenders. 2 years later, they add a public notification requirement. And I kind of wanted to give you a little bit of a visual impression of what the atmosphere really has been during the 90s. I think it has died down in terms of the public kind of hysteria about sex crimes, but it's clearly still a latent feeling that exists. Now, I wanted to give you a sense of what these registries look like. Now, I pulled this up from my computer at my house by putting in the zip code where I live. So here is one good example. And I picked him randomly, but the more I looked at this particular example, the more it exemplifies so many of the problems with this registry. My favorite is always the alias. So the man's name is Robert Christopher Mays. So his alias is Robert C. Mays, which is your standard abbreviation for your middle name in the US. You notice the photo is from 2019. They have to be regularly re-registered and updated. He has to give both his home and his work information and has to be registered in both places. Now, much more interesting is the date of his initial registration, which was December 29, 2004. You notice he's been on this public registry for 16 years. Presumably he has been crime-free for 16 years, but still his picture is right there for everyone to see. Date of conviction, June 8th, 2004. Just 6 months later, he registers. He couldn't register unless he were released. So this means he actually had a relatively short sentence. Don't ask me how that matches the crime of conviction. It does not under Virginia state law. So something is wrong in this registry. The other disturbing aspect of this, so this is designed to help me appreciate the danger of this man in the community, me as a random citizen. I have no appreciation of his danger because I don't know what his crime was, who the victim was, whether I should be concerned, whether my son or my daughter should be concerned. And really, after 16 years, I'm not particularly concerned about anything with respect to him. But here you're getting kind of the sense, what was the goal? Stranger danger, protection of the person who is a convicted sex offender. And this was based on the premise that all sex offenders have recidivism rates of close to 90%. In fact, the Supreme Court justice made this argument, and that there's absolutely no effective treatment. This was season 1, of Law and Order. And what you see is community saying to the officer, you let a child molester live here among our children. Stabler, the abusive cop's responses, don't ask me, I agree with you, blame the parole board. So again, this notion nobody should ever be released. And then on the right, you have Stabler's colloquy with a psychiatrist. And the psychiatrist says, not every sex offender is a repeat offender. And you notice Stabler's response, you show me a first-time offender, I'll show you someone who has never been caught. So clearly this notion that everyone repeats. Now we've actually in the last few years seen somewhat of a change in the legal attitude. There are some courts that have now found some of these registries to violate the 8th Amendment. There are some district attorneys in California that have found the registry to be utterly unhelpful because basically you had on the California registry men who were convicted of consensual adult gay sex, clearly illegal, legal today, but wasn't legal in the 1950s, to a repeated violent child rapist who will never, who was released, but kind of committed very heinous crimes. That is utterly useless as a law enforcement tool, and it certainly utterly loses to the citizens. So in fact, the district attorneys in California lobbied for a change, which is why this lifetime mandatory registry for everyone was shrunk to more serious crimes, and you now have a tiered system. There's also been serious violence and threats against men on the registry to move them out of the neighborhood. There were attacks against them. Many of them end up homeless, and without a permanent home, it's very difficult for the police often to find them. So if there is a public threat, there certainly is a greater threat to public danger when they're homeless. There's also a big movement now to take children and at least children under the age of 16 off the registry or never have them registered. The latest legal development just came this week. The American Law Institute, which is a highly respected entity with lawyers, judges, legal academics on it, just voted to approve a project that would abolish public notification if it were adopted by the different states and limit registration to only very serious offenses and to only limited periods of time with the possibility of early ends. So this is an incredible change in the legal system's perception. Now, the question is, what will be the public's reaction to this? Let's see whether law and order could actually help us in understanding this. This is from the current season, an excerpt. Pedo Motel stands for pedophiles, and it reflects this issue that because of public notification and registry, many of them have found it very difficult to find housing and often end up living together. Oh, I see that the sound does not work on this one. I was afraid of this. What happens is that Benson is the one who says to her team, which speaks very negatively about sex offenders and the pedo motel, and she says, stop. I know you don't want to hear that. I know people don't want to hear this, but people on the sex offender registry have the lowest recidivism rate. That is just shocking in light of how highly regarded she is and the importance of a statement like that in a show of this caliber. I really would not want to underestimate this. Let me see whether I can make this move forward. So I think what we're seeing is the kind of mutual information and reinforcement that happens between legal developments and these fictionalized dramas and really the public opinion that comes out of this. I mean, you have to keep in mind that it's 6 to 7 million people who are watching the show as it is running. And then there are many people who are kind of watching it after it runs on streaming services. Now, the big question for me, though, is how much will this really change? How much can this impact criminal justice reform? And I think the reality is you may kind of see changes to things such as the registry. I think a show like Law and Order could really make a difference in how this is being discussed. I don't think they're quite there yet, but they could do this. But the problem is the underlying dichotomy between good and bad is still present. And that's really kind of standing in the way of true change in the US. There is still this notion that sex offenders are incredibly evil. They're really kind of the epitome of evil, and they're incurable, and they will reoffend. What that also does to victim survivors is that they must report to save others. And you see this in some of the shows, even though Benson talks about empowering victims, she often forces them to proceed with a prosecution, often against their objections. And one of the consequences clearly is that whatever happens to a sex offender is ultimately justified and becomes fully acceptable. And that goes from police abuses. We have moved off the roughing up, which used to be Stapler's specialty, to kind of questionable information being given to someone who is suspected, questions, I think, about search warrants, all of these types of things. very abusive overcharging practices, and oppressive plea bargaining. That's even made harder by the fact that the district attorney is a very likable young man. Threats of prison abuse, especially prison rape, continue. And then incredibly often you see the registry used as a bargaining chip. Interestingly enough, I think it was the last episode where the negotiation over the deal was non-prison sentence, but registration, but not for public safety purposes, to prevent, in this case, it was a female offender, to prevent her from ever getting custody of her child. So here we have an example of somebody who will be on the registry. I could pull up her name if she were a real person, but the whole purpose of this registration was to have an impact on family court, not to tell me that she is actually a threat. So I sometimes wish that they had an hour after the show to discuss the problems with it, but they obviously don't. And so what we're seeing is still all these tensions about gender relations, illness, evil, and especially risk tolerance in the US, reflected both in our discussion about criminal justice reform, but also reflected in law and order. And as I said at the start, we'll see this at least for one other year. And my suspicion is this show will continue to be renewed. And now we have a new franchise already coming on with Stapler back in charge, which may tell you a little bit about how the American public actually thinks about even some of the more abusive officers. So he has changed. He's no longer abusive. And possibly a show about defense lawyers, which could be quite interesting in terms of telling us what really has changed in the perception of the two different players in the systems. So thank you so much for bearing with me on this tour de force through media and the criminal justice system.
Thank you very much, because it was really very stimulating, very original approach as well. So to show this angle, and thanks to the three of you. So I will leave the floor first to the audience. If they've got questions, don't hesitate to raise your hand or to send a little message. So Mrs. Lydiana Sheira, I'm sorry, I'm probably not pronouncing your name
Yes.
that well.
Yes, it's okay, no worries. First of all, thank you to all the speakers, because there were very interesting topics and also original, let's say, in original way, they talked about it. And I had a question for Professor John Baker, which actually a curiosity, so nothing, I hope nothing too long, but he said that the Philippines are made of 7,000 islands, and there are different strata of law, like Islamic law, indigenous law, and all of that. And I was wondering, are there islands that are remarkably, either of them, like are there islands that are remarkably Islamic, under Islamic law influence more than Spanish law and etc.?
Even though I have not been there, it's my understanding for many years that the heart of it was in the Mindanao area. An uncle of mine was actually a professor at a university in Mindanao many years ago during a peaceful period. When I was speaking for the US in the Philippines, I visited with the council's State Department people. And we talked about, at the time, there was violence in those areas. So I was never about to go down there, and basically I never left the island of Luzon. So I don't have a deep traveling background there. But it's my understanding that that's where the dominance of it is. And according to what I've read, it hasn't penetrated that far north, but the conflict has involved North and South at various times. And then we've had periods where the president, under a couple of presidents, were very forceful and imposed martial law, and that created more problems. So it's, when you don't have a good constitution, and here's the irony, when I was over there, I heard the speaker say, we've got to change our American style constitution. I said, you don't have an American style constitution. You don't. They think they do. I also heard it said when I was over there, the Philippines is the only Latin American country in Asia. And it's not just that it's Spanish background, they have the same attitude in Latin America. Olivier knows our colleague from Argentina, Santiago, and he would say in his classes, we have an American Constitution. I said, no, you don't. Why? Because one, is not drafted like one. Two, you give powers that we would never give. So it's very difficult to compare things, and it takes an in-depth study of some of these countries that, I've not done. I find these places fascinating, but I find lots of places fascinating. So I hope I've given you enough of an answer.
Thank you very much, both Viviane, for your question and Professor Becker for your answer. I've got, I don't know if there is some other question. I've got a question for Professor Nora Demleitner, because it was really very interesting what you said, and the example you gave, and because this question of law, the border between law and morality is at stake as well, unfortunately, in Europe these days, and above all on all those questions like pedophilia, etc. So it's really something that we've got in the air, which is not that good for democracy. I think so. So definitely not. But from a legal point of view, coming from France and having a basic knowledge on the US legal system and the criminal law in the US, usually people in Europe, when they face the criminal law in the US, they are always attracted by the US on one point, which is that you've got not only the petit jury, but you've got as well the grand jury. And so many people think that because of the existence of a petit jury and a grand jury, and the grand jury is in charge of the indictment, from the European perspective, we've got this idea that it means that citizens have a better knowledge of the judicial system and of the issues. So it seems that it's a more democratic system because citizens are in the heart of the legal system in the United States. So from this perspective, one can think that because people will be more aware, citizens will be more aware about the legal system, they will be ready to use it in a more appropriate way, or with a better distance. What is your approach of this? So,
this is fascinating what you just said. I think on the grand juries, I mean, not everyone has them, but they actually play a role in law and order. But they are a standing group. And I think personally, I know actually a few people who've served on petit juries, on trial juries, even though trials are so rare these days. But I've actually never met someone who's been a grand juror. So that may kind of be totally anecdotal, but also perhaps tell us about how deep that knowledge really goes. I think right now the discussion about grand juries is actually the opposite to some extent, because they are so controlled by the district attorney that even those who are exposed to the legal system, they're really exposed to it extremely from one side only. I mean, it was Saul Wachtler, the former chief judge of the state of New York, who keeps on being quoted for having said the grand jury would indict a ham sandwich if the district attorney told them to do so. Which is why in these police killings by police officers of civilians, when the grand jury does not vote out an indictment, the assumption is always that the district attorney did not want an indictment and didn't try very hard. I don't think that's always true, but certainly kind of the ham sandwich notion indicates that there might be something to that. So I don't think we have a deeper appreciation of the system from that side necessarily. I think where we may have increasing exposure is just with law enforcement, especially through traffic stops and them enforcing more civil laws increasingly. But I'd say not on the systemic side. But it's a fascinating comment, which I had not thought about before.
If I could, I'd like to add to that. Historically, the United States was prepared in large part for what happened after the War of Independence by the fact of juries. That's where most Americans at the time actually did learn about not only the law, but what's most important is that they learn to make judgments. Now, this thing that I'm going to tell you may offend some people, but when I was a prosecutor, I had two rules in picking a jury. One, don't pick an academic unless he or she has been mugged, okay? And it worked out, worked out very well. The other one was don't pick a social worker. Why? Because they're very sympathetic to the victim. And the crime victim was not there, but the defendant is there and was viewed as a victim. But there's also a federalism point here. What was said about the grand jury differs from state to state, from city to city, and especially federal to state. You know, a lot of people don't talk about how easy it is to indict in the federal system on the assumption that somehow the federal system is always fair, which it is not. I had the occasion after I was prosecuting cases and was teaching, I was asked to go into a New Orleans grand jury and to discuss with the grand jurors, make a presentation on causation. These ordinary people had the best understanding of causation that I could imagine. Causation in criminal law is very difficult, actually, in tough cases. And this was a case of a police officer killing, the charge was, or the consideration, somebody who had been arrested and who died in the van on the way to the emergency room. I wish my students could have had as good an understanding as these people had. So they really work hard at it. But plea bargaining has changed a lot of this, where very few cases actually go to trial, as has already been said.
Thank you very much, to the two of you. Is there another question? Yeah, I let you think about
Just
this.
if I may make a very quick comment about the reference made by Professor John Baker to our European, continental European quest for coherency. Well, this is something which is probably is something linked to the past. This value of coherency, or this thought linking coherency to our historical experience of codes belongs to past. And we moved from the codal culture or codal heritage long ago. and we became much more incoherent. If we were coherent, I don't know, I'm not sure, but yes, our image, our portray, our depiction is that of a coherent legal culture, but is far away from us nowadays. So yes, I end up probably this with a discouraging comment, or displacing.
Well, actually, I'm certainly aware of that since the introduction of the European courts, and I wasn't going to get into all that, but at least there was that image. But your courts have gone in the direction of trying to emulate the U.S. courts, and my view is they've adopted the best and the worst of both worlds. And in many ways, you're more incoherent. But I wanted to go back and also mention in relationship to Professor Demleiter's comment about the influence of television. It's not restricted. I was given a lecture one time in Brazil, and after the lecture, a judge stands up. They were all judges. He stands up and he was very angry. He says, "I am really tired of defendants coming in and demanding their Miranda rights." And he wasn't joking about it. He was serious. That can be for good and for bad.
You're right. We've got the same experience in France because many people are watching movies, American movies, and so they do think that it's the same thing in French court. So, but concerning your observation, Biagio, I'm a little bit more optimistic than you are. I think that you're perfectly right in saying what you said, because we've got a trend, that this is a political trend, to modify the legislation for political purposes and not for the long run, but for the short term, unfortunately. But fortunately, we've got higher courts, which are much more cautious and which are working pretty well. Thanks for the moment and for the stability of the democracy. So they do resist where legislators do not resist that much. And I think that the European legislator works pretty well, and we can see a strong cooperation between the European Commission for one hand and the European Parliament as well. And we have to say as well that the Council of Europe, the European Court of Human Rights, is working very well, even if I agree with you, I'm not that optimistic when I see how the European Court of Human Rights is criticized very unfairly and has no more support from, for example, UK, but not only UK these days. And I really appreciated as well, Biagio Ando, your presentation, and it makes me think about the jurisprudence of the European Court of Human Rights. And so it gives me ideas. So it was very stimulating. Thank you very much. So thank you really, thanks to the three speakers, because that was really a pleasure. I'm really sorry, John Becker, that we couldn't see each other, because I think we will have things to say and to share together. So we will keep in touch. I hope to see you as well in Louisiana, or if you travel in Lyon. That will be really my pleasure to invite you as well. So thanks to all of you, and thanks to the audience. I'm sorry that I had to be very careful with the time, because you've seen that we've got now the general meeting to close this Juris Diversitas Congress. So thanks to all of you. That was very inspiring, even if we finished on some comments which were quite pessimistic. So But thanks a lot. And thank you, Nora, because it was a very interesting presentation as well. Thank you very much.
Thank you.
And
Thank
take
you.
care.
Thank you all.
Thank you.
Bye, Anne. Bye.
Bye
Bye.
now.
Thank you.
Bye bye. Have a nice
Bye,
meeting.
Biagio.
Thank you.
Bye. Bye,
Bye.
Domitilla.
Bye-bye, Domitilla.
Bye.
Bye,
Bye.
Anne. Bye. Bye, John.
Bye now.